Good afternoon, class. In lieu of the class for tonight, since I will not be able to meet you, considering that I have been invited to lecture for the MCLE and it will be in Makati, so I'm going to give you this introductory lecture on the types of employment in the Philippines, which is actually what we are supposed to study if I were able to meet with you. But as I've said, okay, I would like to apologize for that. It was a last-minute engagement, but in any case, I hope that you're going to listen to this lecture and relate it to the cases which I assigned to you and which are going to recite in the following meeting. Okay? So in the Philippines, we have how many types of employment? Okay, we have regular, casual, project, seasonal, fixed term, and probationary. However, take note, under Article 280, it only talks about regular and casual employment. But if you're going to break down the components of this particular provision, then you will see that it actually talks about 5 types of employment. Okay, so let's read the provision. Sabi, the provisions of a written agreement to the contrary notwithstanding, and regardless of the oral agreement of the parties, an employment shall be deemed to be regular, and now it is talking about regular employment, where the employee has been engaged to perform activities which are usually necessary or desirable in the usual business or trade of the employer, except where the employment has been fixed for a specific project or undertaking, the completion of termination of which has been determined at the time of the engagement of the employee, or where the work or service to be performed is seasonal in nature and the employment is for the duration of the season. So it now talks about regular employment, then we also have fixed term employment, then project employment, and seasonal employment, all in the first paragraph of Article 280. Now, second paragraph, it says, an employment shall be deemed to be casual if it's not covered by the preceding paragraph, provided that any employee who has rendered at least 1 year of service, whether such service is continuous or broken, shall be considered a regular employee with respect to the activity in which he is employed, and his employment shall continue while such actually exists. As worded, this is our definition of what regular employment means, what casual employment means, what project as well as fixed term employment means, as well as seasonal employment. Okay. So, kita natin, diba? First, we talk about regular employment. Okay. So, first, you need to talk about the so-called reasonable connection between what? Between the particular activity performed by the employee and the usual business or trade of the employee, of the employer rather. So, let's say, nandun siya sa manufacturing, okay, manufacturing yung kanyang trade or business, then you look at the connection of the work being performed by the employee in relation to that particular business or trade of the employer. Okay. Now, the emphasis is of course on the necessity or desirability. Kailangan ba, okay, yung ginagawa nung employee or yung employee mismo saan? Dun sa particular activity. Okay. So, it only means that if the employee performs activities which are considered as necessary and desirable in the overall business setup or scheme of the employer, then the law will regard that employee as regular. Okay? Now, pwede rin na alin? Pwede rin na not necessarily desirable or related to the usual business or trade of the employer. But this time, it will now boil down to whether you have been engaged for what? For more than a year. Okay? So sabi, the labor code also considers as regular employment casual arrangement or casual employment where the employee's engagement has lasted for at least 1 year regardless of the continuity. So pwede na putol-putol yon. Okay? And this time, instead of the nature of the function or the work being performed by the employee, ang nagiging basihan natin kung irregular siya o hindi is the length of time or the period during which he was engaged. So let's say particular employee, no, nasa sales siya, even if the usual business or trade of the employer is in manufacturing, then pwedeng sabihin, oh, it is not necessary or it is not desirable. However, that particular employee, no, kahit na minimal lang naman yung work niya, and then he is being engaged on an on and off basis, but for more than a year he has been engaged as such, no, by the employer, then that casual employment which he has may now ripen into regular employment because of the length of time by which the employer has engaged his services. So dalawa ang pwedeng pagsimulan, di ba, ng pagiging regular employee mo. Isa is in relation to your tasks or the functions being performed, such as if it is usual, it is desirable rather or necessary in the usual trade or business of the employer. And then second is if you are continuously being hired or being engaged and your engagement has lasted for at least a year, even if such engagement may have been broken. Okay? Kaya dapat yung management careful dito, di ba? Kung talagang kinuha mo siya only for a specific period, then do not re-engage. Diba? Kasi ma-obvious na yon, that you're trying to circumvent the law and you just don't want to regularize the employee. Okay? So parang pupunta na sa saan? Pupunta ng magiging necessary or desirable na yung engagement niya if you do that, no, for more than a year. So by virtue, no, of the re-employment, the rehiring of that employee for 1 year, even if at first it might not appear that the function, no, being performed or the task being performed or the activity being performed by the employee is not necessary in the usual trade or business of the employer, then kailangan na rin siyang irregular. Okay? He will attain such status. Okay. Now, what about project employment? Okay. So, as the law says, project employment contemplates an arrangement, no, between the employee and the employer whereby the employment has been fixed for a specific project or undertaking whose completion or termination has been determined, no, or set at the time of the engagement of the employee. And this is also based on Article 280 of the Labor Code. So, yun yung basihan niya. Okay? Kasi meron kang specific project. Okay? So, ano yun? You are considered as coterminous. Your employment is considered as coterminous with what? With that particular project. Okay? So, will there be illegal dismissal later on if you were not rehired? No. Okay? So, the services, your services, will be legally and automatically ended, no, or terminated upon the end or completion of the project. So natapos, kunwari, let's say construction, doon ka lang talaga hinire for that particular period, maybe as in-house engineer or something. So natapos yung project, then that's it. Okay? So the basis is not the period. The basis is the completion of the task itself. So, kumpara let's say sa regular employment, kapag sa project employment, tumagal ka, sumobra ka na sa 1 taon, pero yung project kasi is hindi pa tapos. So, you cannot say that, hey, irregular nyo ako kasi magpas na ako sa 1 taon. No, that is not the case. Because your engagement is coterminous with what? With the project itself. Natapos na yon, there is no termination, there is no dismissal to speak of. What you have is simply an ending to your engagement because it is coterminous with the project or the activity or the undertaking. That is project employment. Now, on the other hand, punta naman tayo saan? Dun sa tinatawag nating fixed term employment as opposed to project employment class. Fixed term employment now is based on the period. Okay? So, it is valid when? Okay? Yung mga instances. when the fixed period of employment was knowingly and voluntarily agreed upon by the employer and the employee without any force, duress, or improper pressure bearing upon the employee, and absent any other thing, no, or circumstances vitiating his consent. Okay, and or rather, or it satisfactorily appears that the employer and the employee dealt with each other on more or less equal terms with no moral dominance exercised by the former or the latter. And the landmark case in this, of course, is Brent School versus Zamora, which I also assigned to you. So please read that case in the original and understand all of the nuances of that particular case. So in that case, diba, if I remember correctly, he was hired for what? To be a coach, no, in the school. And then he was saying that I think after 3 years, I should be regular. But the school insisted that no, you were hired only for this 3-year period. Okay? Correct me if I'm wrong. I am not that familiar anymore with the facts of the case, but that's how I remembered it. But bottom line was the court upheld the contract. Okay? According to the court, when this coach, when this member of the faculty, because he was a member of the academic staff, of course, because he was teaching, he was teaching as well as coaching, I think. So when he was engaged, he knew that it will be for that particular period only. Okay, so I think 3 academic years, and that's it. No? And at the same time, since he had a college degree, he knew what he was signing, he understood the contents as well as the import of the employment contract. The court held that it satisfactorily appears that he, as well as the school, which was his employer, more or less dealt with each other on equal terms. Okay, there was no vitiation, no improper pressure, walang pilitan, hindi siya kapit sa padalim level wherein he did not know what he was signing, or that he was really forced to accede to the terms of the contract. Okay, so what the court said was, what you entered into is fixed term employment. And again, if you are not rehired, if you are not renewed, then there's no dismissal to speak of. Rather, it is just the natural course of things. When your engagement is finished, then that's it. Okay? So there's no dismissal whatsoever. Okay. Now let's go to seasonal employment. Okay. So it is defined as where the work or service to be performed is seasonal in nature, and the employment is for the duration of the season, also under Article 280 of the Labor Code. Now, seasonal employees may be considered as regular employees. Okay? So, pwede siyang mag-ripen din, literally mag-ripen into regularization. Why? Okay? So, for instance, farm workers, kasi dyan nagsimula naman talaga yung konsepto ng seasonal workers. Sino to? Yung mga hinahire sila kasi planting, harvesting, etc. So, yung mga sakadas way back when. Okay? So, they move from one hacienda to another, they offer their services, etc. So, seasonal. Okay? Literally, by season. Okay? So, farm workers is just an example of that. Sabi nga natin, yung historically ang pinagsimula ng konsepto ng seasonal workers. So, regular, they can be considered as regular seasonal workers when? If they are called to work from time to time. Okay? And the court in several cases characterize the relationship of the employer and the employee in this particular wise. Sabi ng court is the nature of the relationship is when the employer is such that during the off season they are temporarily laid off. So wala ka, di ba? Kasi wala kang trabaho dahil hindi yon iniintay yung mga pananim na lumaki or whatever. Okay? But they are considered as being re-employed during the summer season or whenever their services may be needed. Okay? So, they're considered as still regular kahit na seasonal because of the nature of their job, which is necessary and desirable in the usual course of business of the employer, and not necessarily because of the length of time they have worked, because in some of the cases involving with the determination of whether a person or these persons are considered as seasonal workers or not, seasonal casual as opposed to seasonal regular workers, is that they have been working for the same hacienda, di ba, or farm for years on end. So they come back, no, every planting season and they do it. Or later on, they come back for the harvesting season. So yung off season nila is when, they allow the plants to grow, walang gagawin, di ba? Or it can be managed not by a large number of people anymore, just a few would do. So ayun, hindi kailangan yung kanilang services. Okay, so day in, well, not really day in and year out, they have been engaged. Kaya are they considered as regular because of that engagement, continuous engagement, which span decades? No. According to the court, no, in one of its decisions, it is because of the nature of their job. Okay? So they are considered as regular for that particular job because they've been doing it, okay, over and over again. It is necessary in the usual trade or business of the employer, and they are considered as merely being laid off during the time that they're not working, which is the off season. Okay? You will understand seasonal employment when we study the cases under this. Kasi, yun nga, merong regular seasonal, merong casual seasonal. Kasi pag sinabi natin casual, you are employed, there is still employer-employee relationship, okay? But you do not benefit, no, from the what the regular employees will get. So your engagement is merely casual. And then finally, we have probationary employment. Okay, so this is actually, some authors would say probationary employment is not a type of employment when you put it side by side with all the other types of employment which I have discussed so far. But still, a lot of authors, on one hand, would think that yes, it is also a type of employment. Sabi nila, parang status lang to. Okay? So, not really a type of employment, but just a status of employment. But when we say status or type, at least in contemplation of labor law, pwede mong pagbalik-balik na rin yan. Diba? What's your employment? What's your status as an employee? Regular ako. Fixed term yung sa akin. Or project ako. Pwede rin naman na pwede rin naman sabihin, uy, what kind of employment or what type of employment are you in? Ganun din. Pwede mo rin isagot, regular ako o casual yung employment ko. So, medyo pwede siyang pagpalit-palitin. Kaya, it doesn't matter, no? Whether isagot nyo na one type of employment is probationary employment, or you can consider it as a status. Kasi, probi pa lang ako, diba? Parang tinitingnan pa nila yung fitness ko because that is the purpose of probationary employment. Okay, so as part of management prerogative, before hiring, before hiring because you are hired as a probationary employee already, but before making you, a regular employee, the employer is given the chance to check your fitness for the job, whether you are a good fit for the company. So that's why you undergo a probationary period. Is this required? Not necessarily. You can be hired from day one, considered ka as regular. It depends on what is stated in your employment contract. However, okay, pwede ka rin namang dumaan sa probationary period. And how long is this? Okay? Yung test mo for fitness. Usually 6 months. Okay? What the code says, 6 months. Meron naman na longer than 6 months. Okay? We have that particular case which says that yes, you can have a longer period of probationary employment or probationary status. Then you can also make it shorter, not necessarily kung kaya mo na within 3 months, then alam mo na, fit na, diba, na-test mo na, na-assess mo na yung kakayahan ng empleyado, then you can already put him on regular status. Tapos na yung kanyang probationary employment. So, in the absence of any agreement, whether it is longer or shorter, then it is usually 6 months. Okay? And within that period, the employer is supposed to gauge your fitness, assess your competence, and decide whether you will be a good fit for the company. Okay? So probationary employment exists when the employee, upon his engagement, is made to undergo a trial period. Diba? Sana lahat, sana all pwede may trial period. But, well, sa labor, meron. Ito yon, probationary employment. So, where the employer determines the employee's fitness to qualify for regular employment. Okay? And ito lang yung mga kailangan ng mangyari, di ba? Based on reasonable standards made known to him at the time of his engagement. So he must know ano ba yung standards, di ba? May quota ba? Sales. Meron ba na kailangan, let's say, criteria, okay? In terms of attendance, in terms of, let's say, the type of output, the quality of output that you have to submit. Ayun. So you know at the time of your engagement that you have to meet this criteria. You have to meet this quota. You have to meet these standards at the time of your engagement. Okay? Not later. Not after. Kung kailan tapos na yung probationary employment, bigla kang bubulagain na ay hindi mo na-meet yung standards. Okay? Doon nagkakamali ang ating mga employer class. Bakit? Kasi hindi nila nasasabi agad, ito yung mga standards na dapat mong i-meet. Okay? So, kahit na talaga naman, di ba, na hindi pumasok, di ba, hindi pumasok no sa kanilang criteria, hindi tuloy, hindi magiging valid yung kanilang pag-terminate ng probationary employment kasi hindi aware si employee, ito pala yung dapat kong gawin. So, dapat naman talaga, alam mo, di ba? Kasi mahirap manghula. Ano ba, tama na ba, sapat na ba ako, sapat na ba yung ginagawa ko? So you have to know that, and you have to be able to recognize whether you are being assessed accordingly. Okay? Now, so the employer must make known to the employee the standards under which he will qualify as a regular employee at the time of the engagement. And if no standards are made known to that employee, okay, then automatic considered as regular employee. Okay? So, generally again, the employment shall not exceed 6 months. And this is based on Article 281 of the Labor Code. Okay? So, during the time of your probationary employment class, then you also enjoy security of tenure. Okay? So, pwede ka lang alisin. For what grounds? Under the same grounds as why you may be justified to dismiss an employee. So, either just or authorized causes only. Okay? Kasi, may naka-lockdown ka dun sa period na ina-assess ka, na tinitingnan yung fitness mo, yung probationary period mo. Okay? Now, what if, let's say, yun nga, longer than 6 months? So, it depends on the nature of the task. In one of the cases, I think it's the Verb-Wizard case, no? Wherein the employees, parang 1 taon yata ang kinailangan nila to qualify. Why? Because they were copywriters and sales persons, and they solicit mga paid advertisements to be published in the Yellow Pages. So baka hindi na kayo aware sa mga Yellow Pages, kukunti na lang yun yung ating dati yun, walang internet, kaya doon lahat ng alin, andun mo titingnan, saan ba merong tubero, saan ba magaling magpa-repair din ng mga ganito. So businesses would place ads in the Yellow Pages, and according to the decision of the court, okay, so para makita mo yung fitness ng mga salespersons na to, di ba? Malalaman mo lang yon pag na-publish na yung Yellow Pages. And kapag nag-pick up na, yung may feedback na from the businesses which place their ads, kung effective nga, di ba, yung mga nag-solicit ng mga ads, ng mga ng mga paid advertisements na yon. So, doon daw. And the entire process would take 1 year from the time that they solicited the ads and placed it for placement rather on the Yellow Pages up to the time na distribute, di ba? Na benta o na distribute yung Yellow Pages sa mga households, kasama dati households doon, and including other business establishments, and until parang cycle. So dapat matapos yung cycle to know whether or not they were effective in their particular tasks or functions. Okay, that's why the court allowed that a longer period of probationary employment. Now, how about double probation? Okay, so cover na rin natin, although it is jurisprudential in nature, bawal yung double probation. In one of the cases decided by the court, ang ginawa sa kanya, OJT muna siya dito. I think it is a Onasan case. So, OJT, and then doing the same job, ni re-engage siya. Okay? Nilipat lang ng ibang department, pero doing essentially the same work, and this time probi na. Okay, so sabi, probationary status ka na, so 3 months and then parang 6 months yata, this time for probi. And the court said, teka, hindi, okay, hindi pa ba sapat yung una ng OJT niya? Kasi it would appear that natuwa ka, di ba? Natuwa kayo sa performance ng empleyado, nung hinire nyo, kasi on the job na yung training niya. Okay? And not part of any curriculum whatsoever, kasi if it's part of the academic curriculum, then okay lang. But he was hired as an on-the-job trainee, not as a part of any academic curriculum of an academic institution. So, she was hired, and then yun nga, nilipat lang, and then gusto na naman itong employer, I think it's a hotel, na probi ka. Sabi, no, hindi na siya dapat probi, because she actually already made it, no? Meaning, it appears that she has already met the standards, kasi kinuha niyo siya ulit for that, diba? So, hindi pwede, because that would amount now to double probation. Okay? And that is prohibited under the law. Okay? Hindi pwede, kasi it's as if you are circumventing, diba, the law. You are delaying giving the regular status to the serving employee. So, otherwise, diba, ipapayagan natin yon, laging OJT, and then probi ulit, and then bago ma-regular, diba? So, tumatagal, diba, yung kung kailan magkakaroon ng regular status empleyado. Now, why are we so keen on getting this regular status? Because most of the benefits, if not all of the benefits that we have, are accorded to those with regular employment. Okay? Kasi yun talaga ang hinahangad mo. Pag regular ka, mas meron kang karapatan. Okay? Mas meron kang mga benepisyo. So, usually, there are benefits given to regular employees of a company which are not enjoyed by those who are on fixed-term contracts, or those who are seasonal, or those who are still under probation. And that's why in the private sector, talagang yon ang gusto. Now, in the government sector, meron pa bang probate period? Yes, pwedeng maglagay. Technically, dati meron, parang 6 months din. Pero ngayon kasi, with the appointment process, if you are given a permanent position, then that's it. So you already have that security of tenure from day one. So wala nang practically wala nang probate period pa yon. Yun na yon. Ibig sabihin, once you are appointed, you have met all of the qualification standards or QS, etc. You have undergone all the exams and interviews. So to the mind of the prospective employer or government agency, then okay ka na, pasok ka na. Okay? So with that, I would like to end this short lecture just to give you a brief introductory lecture on these types of employment, and I hope that this will serve as your framework when you read the cases. I'm assuming that you have read some of them already in preparation for tonight's class sana. Just continue reading them, and then use my lecture as the framework. Saan papasok, di ba? Bakit ganon? Bakit nasabi ng Supreme Court that this is how you treat these workers? Okay? Na regular seasonal pala sila. Okay? So, I hope that this would help you, in your study of the cases. And then again, my apologies for not being able to make it tonight. My lecture is actually from 4 to 7 p.m. But yun nga, Makati, so I will not be able to really make it, okay, in time for your class, and I don't want to disturb you from your other readings and other subjects. So please use the time wisely. Use it to read the cases which I have assigned. Use it to watch this video, this lecture, and then also use it for your other subjects. Okay? So maraming salamat, and I'll see you next time.